Good afternoon. Good afternoon.
Good afternoon, sir.
Good afternoon. Are we ready? Are we ready?
Yes, sir. Yes, sir.
All right. First thing, I sent like an handout, something that you can read on international environmental protection. Do we all have it now?
Yes, sir.
All right. So I don't foresee that this is a. Sorry, can I give me 1 minute? 1 second. I'll call you back. All right, sorry about that. I just received a call. All right, so I don't envisage that we will spend too much time in today's on this topic. It's a pretty straightforward and just another aspect of environmental law, laying foundation for how or the principles behind some of the treaties on environmental law that we see today. And because it's international law, because the environment relates to the environment has extraterritorial effects, which means that something that you do in country A can have effects on country B. So the the international community thought that it would be good to have like a background principle. That background principle would then be reflected in international treaties, both multilateral treaties and bilateral treaties that states enter into, and that those principles would form the basis for subnational and regional design of legal frameworks for environmental law or any form of environmental regulation. So essentially, what it means is that these international environmental law principles would form the framework, would form the background, would form the underlying jurisprudence upon which states, both nation and regional entities, will tailor their their treaties and national law towards. And if you look at some of those principles, you would see that they reflect some of those underlying basis or justification for the protection of the environment. So, for example, so in the handout that I sent, I listed some of those principles that guide the ways and manner in which countries or international bodies must deal with the environment. It has a long checkered history in the sense that it developed over time. So it's not like there is a particular meeting or a particular conference where parties sat down to then agree that these are the international principles that would govern environmental law. So it started gradually from states exerting powers over their territories and the limits of that territory. And I think the first principle that we looked at that I gave you is the principle of national sovereignty, PSONR, principles of sovereignty over natural resources. And that was in the 1960s when the United Nations General Assembly enacted or passed the General Assembly Resolution 1803, exerting or establishing the sovereignty of states over natural resources. And it might seem like an anathema if you look at PSONR as a basis for environmental protection. PSONR essentially is a doctrine, is like a principle that gives states so much power over their natural resources. And so how is PSONR eventually coming to be a principle for the protection of the environment, which is why some experts have said the PSONR is basically reinforcing the right of state to destroy the environment rather than to reduce harm within the environment. But in Regulation 1803, when the General Assembly passed it, there were conditions for the exertion, for condition for the implementation, for the condition for holding on to the right of your permanent sovereignty over natural resources. Now, so what it means is that as an exception to you holding that sovereignty over your natural resources, you have the opportunity or you have the limits not to use your natural resources in such a way that it has a transborder or transboundary effect, or it has an extraterritorial effect that another country or other countries of the world would benefit, would suffer from the exploitation of your. So sorry, something is popping on my phone. Sorry if I'm disturbing you guys. What's transcription about? Hello? Class rep. Is the class rep there? Hello.
Good afternoon, sir.
Good
I think
afternoon.
it's like a subtitle. Yes, sir. I think like a
So who is
subtitle
this?
that will.
A
Sir.
subtitle. Hello.
So as I listen, like as I talk. Can you hear me?
Hello,
You said
sir.
what?
Like it's like more of like something an automated something. It's not like something.
Okay. All right. Before you go and quote me now that this man is abusing the university now. I mean, I used to abuse a lot. So I'm safe. Habib, if you say I'm safe, yeah, if you are the one who saying that too.
Yes,
I will hold you.
Yeah, I presume so, sir.
You presume I'm safe?
Yes, sir. You are safe, sir.
Okay, that's reassuring. Okay, so that's the basis upon which the PSONR was. So when you look at the first principle that we say for that guides environmental protection at the international plane. Now, some of these principles are transcribed. To use the word, let me say, adopted by states into national legislation, but not all of them. And so as we look at some of the environmental challenges that the world is presently confronting, and we look at some of those provisions in terms of some of the, I provided some of those provisions in the handout. Those provisions reflect some of these principles that we are talking about. And in some cases, when I think I have some time, I think I try to highlight some of those principles as they were provided for in those statutes. So if there's anything you don't know, if there's anything you pick from this class, if you don't understand anything, you must understand that one of the fundamental principles, the first fundamental principle of international environmental protection is what? The principle of what? Sovereignty over natural resources, PSONR, which is codified by the General Assembly Regulation what? 1803. And for those that will be doing oil and gas, maybe 400 level. I don't know what level you do oil and gas now. Those are some of the regulations you would also have dealings with in terms of establishing on the basis of Section 43 of the Nigerian Constitution, the basis for the federal government of Nigeria to exploit provisions of mineral resources under the ground, under the guise of permanent sovereignty over natural resources. So that's like the first principle. So with the first principle, when it comes to environmental law, before you can say that you can enact a statute, you can enact, you can agree on an international treaty. That treaty must give concession to what? The principle of PSONR. Any treaty, whether for the protection of the environment or not, must accede to that sovereignty. It operates on the fact that there must be a mutual understanding between states. States, you have the power and liberty to use your land, to use the mineral resources within your land, but don't use it in such a way that it will prejudice every other member of the international community. So, or if any treaty then intends to take away that right of permanent sovereignty over natural resources, then it means that states will have the power, or they will have the liberty to either accede to such international treaty or not. So every international, every environmental regulation must take that into consideration, must take cognizance of the rights of states or the rights of component states, if in case that is, in case you're in a federal country like Nigeria. So what essentially that would mean is that PSONR is a way of expressing the spirit of Section 1 of the Land Use Act of 1978. So the Land Use Act of 1978 is the one that gives the governor of a state the power over land within that particular country, the power over the space within that particular territory. So that Section 1 of the Land Use Act is a reflection of PSONR. It's also a reflection of the spirit of Section 43 of the Constitution of Nigeria over the mineral and natural resources underground within the Nigerian territorial space. So those are these are some of those. That's the first principle that the international community agreed on, seeking to regulate. And I also try to discuss some of the challenges or the interdependence of sovereignty when it comes to international environmental law. And I cited several cases. If you check the case of Kofu Channel case and the Trail Smelter case, those are two cases where the International Court of Justice has established and also reaffirmed the rights of states over their natural resources. And then the second, so you can look at some of those cases, Trail Smelter and Kofu Channel. Kofu Channel has to do with there is a canal called Kofu. So, and the rights over the usage of that canal and the effects that it has on adjoining countries is what the ICJ had to decide in that case. So, several treaties like the Stockholm Convention, the Rio Declaration, and then Section 21 of the African Charter on Human and People's Rights, Article 1 also of the ICCPR and the ISECA are provisions that reinforces the principle of PSONR within David, who is that? Is that David, Daniela, or who is that?
You have any opportunity. Don't say anything carelessly. Do it carelessly. So is it that you don't have
Daniela, please mute your mic.
You think and do it.
Hello,
Why am I
Daniela.
now be looking at you like a dummy? She doesn't know you. This is the only time she will know you a little.
All right. So, I mentioned some of those international treaties, human rights treaties, and so in explaining your PSONR, you have several treaties or several provisions in mind. We mentioned the General Assembly resolution. We mentioned Kofu Channel. We mentioned Trail Smelter. We also mentioned Section 43 of the Nigerian Constitution, and also Section 1 of the Land Use Act. We also mentioned Article 21 of the African Charter and Article 1 of the ISECA and ICCPR. Those are the provisions relating to permanent sovereignty over natural resources, which is reflected in the basis for protection of the environment within the international space. And then there is also the doctrine, the principle of prevention and prevention. So that under international human treaties, it is recognized that the no harm principle is a background, has a background status such that any international treaty or international environmental law regulation must have, before it can be acceptable to international community, that principle embedded in it, which is the principle of what? Harm prevention. That there should be no harm that must be done to the environment in the process of regulation. So if there is any form of regulation that tends to over-regulate, recommend over-exploitation of the environment, that would be contrary, which would further degrade the already dilapidated environment. It would be contrary to international environmental law principles, and that each state, each treaty, each member of this international community must agree to that doctrine in the process of. So what you find is that when states come together at the international either conference, or it can be and I'm sure you know, recently there was COP29 in what's that place now, Azerbaijan, where states come annually to talk about the climate change, and it's now almost like a ritual that every year states travel, different world leaders travel to one part of the world, and then they host COP. That everybody talk, and then sometimes they make some funny commitments. Oh, there is need for this, there is need for that, and then everybody goes back, and nothing changes. The next year they come all over again to sit down and then say another set of stories. I mean, sadly, I'm sure for those of you who are interested in climate change issues, you will have followed and to see the extent of embarrassment that world leaders and even company CEOs make of themselves when it comes to climate change. Everybody makes all sorts of noise. Now we are going to net zero and all that, but then after the year, they all jet out to a particular jurisdiction. Everybody hits, they buy all sort of take pictures, and everybody goes back. Now, in my little interaction with the environment, and since I have been partially with the COP meetings, I've not seen anything that changed within my own personal environment. At least this is Lagos State, and Lagos, and these are states that I live, Lagos and Abuja. Nothing has changed. So those are part of. So what it means that where you have international treaties and that is not implementing in substance the no harm prevention, then it is contrary. That is a basis for challenging the efficacy or even the validity of such environmental issue, which is why you see some countries are really against the whole climate change, not necessarily because they don't believe that climate exists, but because they believe that every year world leaders just assemble themselves and then they do nothing after that few days, and everybody goes back to normal. In terms of their production, in terms of their regulation, sometimes they pass regulations that seeks to follow the no harm prevention, but it's always not implemented. And so those are so if you check the United Nations Convention on Law of the Sea, if you check the United Nations Convention on Law non-navigational uses of water courses of 1997. I highlighted Article 7, Article 21, Article 2, articles and treaties on prevention of transboundary harm and hazardous waste of 2001. I highlighted different provisions, especially Article 2A of that particular treaty, and the International Convention on the prevention of pollution of ships. That's the MAPOL Convention of 1973 and 1978. Those are regulations and Convention on biological. So I gave a long list, and then the climate change UNFCCC convention too. Those are treaties that embodies the no harm or preventive action principle of international environmental law. Now, the third one is the precautionary principle, and I think I explained it when I was giving the course outline, which is that, I mean, from the way it sounds, precaution. Now, so that every international treaty, regulation, or any instrument that your states or sub-regional bodies enter into seeking that is supposed to be an environmental law regulation must have provisions around caution in the use of the environment. So it must be such that the risk of environmental degradation must be scientifically proven, and that when it's scientifically proven, the states can then enact provisions by understanding that risk and how to mitigate that risk for the purpose of to reduce any harm that can be done to the environment. So essentially, what it's saying is that before you regulate any environmental problem or challenge, you must have sufficient scientific evidence. That sufficient scientific evidence is what would help us in understanding the extent of the caution that we need to take. And I'm sure with the precautionary principle, you can almost picture climate change regulations in this regard. So scientific evidence must be there enough. I'm not. I think on climate change there are enough scientific evidence that the ozone layer is being depleted, that some of the activities of man is further destroying the environment, and then the also. So I mean, some international organizations have spent almost decades and billions of dollars trying to understand, trying to investigate whether the connection between the activities of man in terms of manufacturing, in terms of exploration, how it's affecting the environment. And I think maybe what is lacking is the extent to which the scientific evidence can be brought together to establish, to make a stronger case that simply social threats. Scientific evidence, I think there is enough scientific evidence to allow us to activate the precautionary principle in the regulation of our human activity when it comes to the environment. So on that basis, if you look at some of those, there are international treaties, even aside from climate change, that has also reflected some of these principles. If you check the Vienna Convention on the protection of ozone layer of 1985, and then the Montreal Convention of 1987, and then the 1991 Montreal Convention are instruments that, and then of course the climate change and then biodiversity, and some of these Cartagena Protocol on biodiversity, biosafety also Stockholm Convention are some of the conventions that reflect the precautionary principle. Essentially, it is saying that when states, when nations, when international organizations seek to regulate the environment, there must be enough evidence to show the level. It's like you have to understand the problem before you can then prefer solution, before you can enact laws that would indicate the necessary preventive measures under those environments. And so under this also is also the principle of environmental impact assessment. And I'm sure your first interaction will be with the environmental impact assessment will be that of Nigeria, the Environmental Impact Assessment Act in Nigeria. So it's on the basis that in any activity that you want to carry out within territories, within the international, that seeks the environment or to make some form of environmental management, you must understand, you must have carried out an environmental impact assessment. While it is not an attempt to stifle states from developing at the pace they wish, those are some of the safeguards that seek to protect the environment. And I will digress a bit here. And my digression essentially deals with how people like developing countries are supposed to follow some of these principles. For me, I don't have so much problem with some of these principles that has been developed by the international community. But the problem I have is that when it comes to developing countries now, when I mean developing countries, I'm saying the countries in the South. What you see is that there now seems to be over-regulation of human activity. Over-regulation in the sense of when the advanced countries, the developed countries, were developing their territories, were developing their countries, there was practically no regulation. Everyone exploited. Some of them went to developing countries where they are colonizing, exploited every land, every mineral that they could get, including gold, including everything. Now that, so they had the third industrial revolution where they set the pace for what you see now in terms of how they are fully developed now, which is sometimes when I have a discussion with some of my colleagues, I tell them that some of the things that we see, I mean, you look at an American society or like a British society or even European societies, and you see the effect of that industrial revolution. So the industrial revolution to them was, how do we industrialize our economy such that everybody relies on us? And in that process, they did all sorts of dangerous things to the environment. So they came to our countries like Nigeria, found oil, established their shell, all their multinational companies in almost everywhere, took over all they could get from, and then they developed those countries. And so suddenly after they are now fully developed and everything is fine, everyone is going. So what you see now, they are just patching up their developmental issues and all that. Now the regulations started coming when some of these developing countries begin to want to develop at that same pace. So those are some of the issues, some of the injustices that Africans and the countries in the global South established till today. Because what you see is that some of these regulations are not being fair to countries that are seeking to also take the advantage of revolutionizing their economy, revolutionizing their infrastructure and all that. So now you see that before you can carry out any developmental, so before you can build a train now in Lagos, you have to carry out an environmental impact assessment. And because most of the time you are out there to go to some of these World Bank, IMF, IFC to borrow money, they then say, oh, before we can support this project, you have to let us see the environmental impact assessment, because we are really interested in your environment. We don't want you to destroy your own environment. So give us EIA. So sometimes lofty projects, infrastructural projects are rejected on the basis that the EIA is not convincing enough, that the countries or states have not convinced the lenders or the investors that the project could not have an environmental impact assessment. And I think I've been on 2 transactions that was one was a port in, I think, Enugu, and another port in I think Ondo State. So 2 ports that was rejected by World Bank on the basis that the environmental impact assessment is not sufficient, is not convincing enough. So those are the challenges we have when it comes to some of this. Although we all agree, I mean, Africans and most of these third world countries usually agree to some of these principles because we really don't have a say. So most of the time, even our leaders contribute to it. They just go there, take pictures with the president of the United States and all that, and they smile, and then they go back home. Nobody really gets to really hit the nail on the head in terms of how we should, in quotes, how they should free us and let us develop at our own pace, the way they have done their own, the way they have conducted their own affairs. So you will see some of the treaties that I listed in terms of UNCLOS, United Nations Convention on Law of the Sea, the Convention on Biological Diversity. Those are the Ramsar Convention also on wetland of 1971 are also some of those international treaties that reflect that environmental impact. Essentially, they think or they establish or they claim that the basis is to allow for transparency or public participation, and that most of these projects should come from an informed status, so that there will be critical, informed decision making, and to enable the government of those states to balance their developmental objectives with what they call environmental sustainability. So, and that by incorporating that those analysis, those impact assessment processes into the system or into some of those infrastructures, it would then serve as a protection, a tool for protection of the environment, both in the long run and in the short term, on the basis that of sustainable development. Those are some of the justifications for, as much as they sound like big English, informed decision making, sustainable development, and public participation. Those are ways, those are words to make things look like, yes, why won't we make people participate? Why won't we what they call it, have an informed decision making process and all that? Those are things that everyone would think that, yes, at least it makes sense that we should be able to do all these things. We should be able to protect our environment for a long term, so for sustainable development purposes and all that. But that's the other more pro-southern experts have really questioned some of those grandiose claims for environmental impact assessment. And then there is also the principle of polluters pay. This is like the principle that comes to play almost regularly when it comes to international environmental treaties. It comes to play regularly. I'm sure, I don't know if any one of you followed COP29. In COP28, one of the major, COP27 had a major issue of what now? Justice for South, the global South. So the major issue, the major contention when parties sat down, I think COP27 was Glasgow. When parties sat down in Glasgow, it was all about justice and fairness for those who didn't contribute so much to the degradation of this environment that is causing the entire climate change. When it comes to COP28, it was more about action plan. So that it was where people just had to talk to themselves that there is no clear course action plan on how to achieve climate change or how to achieve this existential problem that the whole world is facing. Everybody does come and all that. And then COP29, which one that finished last month, it was more of 29, it was more about funding, which we can attribute to the principle of polluter pay when it comes to environmental protection, which is that for those that polluted more of the environment, they should bear the major parts of the funding for restoration of remedying the damage that has been done to the environment. And I think at Azerbaijan, the countries, especially some of the major polluters, of course, they know themselves. The shells of this world, the Amazons of this world, the apples of this world, who are getting all sorts of chips from low-income countries through forced labor and through lack of instruments. So, for example, if you go to some of these countries, you go to Niger and go to some parts of even in the northern parts of Nigeria, what you see are these core malams digging the floor, not with instruments, but so those are, you see holes everywhere. those are the ways in which the environment is being degraded. And so when they pick up all these things, they transport them to China, they transport them to Vietnam, where they produce some of these things, and then they turn it to iPhone, and then sell it to us at $1,500, and then we continue to use. We pay them back. I mean, it's our products most of the time. It's our mineral resources. Now it's now the Teslas of this world, the BYDs of this world, getting all sort of minerals to manufacture lithium, to manufacture their batteries for electric, what do you call it now, electric cars and all sort of things that they are using all those things for. Essentially, those are the things, including those that are making cars and all that. The best you can do in this part of the world is probably to assemble cars, not necessarily to make some of these cars. So for countries in the developing countries or in the global south that has less contribution in terms of manufacturing, in terms of incidents of destroying the economy, they shouldn't bear the same responsibility as those that are the godfathers of environmental destruction. So this is the principle of polluters pay embodies that particular sentiment. And like I was saying, I think all the polluters eventually agree to a $300 billion as a form of restoration, as a form of payment. Polluters pay for their degradation of the environment. Imagine corporations, IOCs, and all this coming up with $300 billion, and then I don't even know when I first heard that they agreed to a $300 billion, and some countries in the global south worked out when they declared the $300 billion, and so they had to agree to a further commitment of a further commitment which is not stated, but then that they will do more. The question is, imagine before I can drop 300 billion, you know how much I have, you know how much that must have gone wrong. And then the question is, even if the 300 billion is not like it's going into a special account, they are mere commitment of how much they are going to spend. So it's not like you would see anything different. Next year, they are going to do another corporate, and then you ask yourself, okay, what has changed between last year declaration of 300 billion and this time? So most of the time they are just like the president of Nigeria described the climate change when it comes to Africa. He said it's like, I think rats or something in a church rat or something like that. Just invariably saying that it's really not our problem. Let those who really pollute the environment, let it be their problem. I think I agree with him on that. So when it comes to climate change and how the environment is being destroyed, those that are taking at the forefront of manufacturing and technological advancements. In fact, for some of you too, you might probably also be responsible for that. Some of you doing Bitcoin, those are also serious polluters now, because in terms of the mining process and now the consumption of energy, the kind of also environmental issues that it's causing in some jurisdictions. Now, so those are, so I gave different examples. Look at some of the examples of polluter pay that, and generally you notice that polluter pay principle is always, in the case of Nigeria, is always ready, is always present in most of our laws. So especially when you see that when anybody that does this will pay a fine and all that, that's polluter pay principles talking. And then so the moment there is, but then I think we talked about the process of judges giving fine, and then the fine is for what purpose, and that maybe sometimes the fine is not necessarily the problem. Just like we just talked about when it comes to COP 29 gave 300 billion. So where is the money going to? Rather than activities that would restore the environment, which should be the basis upon which such financial commitment should be utilized for. Now, so different, and then I gave examples from the NESRIA and EIA and how they reflect some of these provisions. And then the next one is the principle of common but differential responsibility. And I think the whole idea of polluters pay is also established on that ground, or on the principle of common but differential responsibilities. That the environment is common to all of us, but we all have differential responsibility. We have different responsibility when it comes to destroying the environment. We all have different responsibility when it comes to the activities. When it comes to the activities that affect that environment. Yes, we all are polluting the environment, but there are levels to the pollution of the environment. So you see someone digging a well in Lagos, how does compared to someone mining resources, pouring all sorts of chemicals inside the ground for the purpose of making the land soft and all that, for the purpose of mining, or so we all are degrading the environment, and we can give examples of environmental pollution, destruction within each community, from the rural areas of Kaduna to the city of Lagos. Pollution happens almost every day. Go to in Lagos, you see gutters, you see all sorts of things. You see people urinating, defecating everywhere, destroying the environment. But then the question is it at the same level with those who are polluting, who are destroying the environment on a larger scale? So that is the basis upon which that in imposing when imposing the doctrine of polluters pay, you must put at the back of your mind the common but differentiated responsibility in arriving at who pays what, who pays how, or when, and all these things are put in place. So that is the doctrine, and I gave examples. If you check some of the handouts, you see examples of some of those things that, especially from principles like the Kyoto Protocol, and then the one on climate change, and then there is this convention there's this Minamata Convention. Those are some of the conventions, and Rio Declaration of course of 1912. Those are treaties that reflect that principle of common but differentiated. But of course, it always leads to the concept of polluters pay for the purpose of environmental degradation. And I gave a typical example of the climate change instrument that Nigeria has entered into when it comes to common but differentiated responsibility, in line with some of the international regulation and instruments. And then the next one is the principle of intergenerational equity. I think I've explained that intergenerational equity is just simply trying to protect the next generation and trying to give them a level playing ground, that they should also have the opportunity to enjoy the environment the same way we are enjoying the environment now, on the basis that if we are around in this generation, we must not utilize the environment in such a way that it's prejudice the future generation from having similar experience or having their own fair share of the environment. So now, in looking at that, it means that the present generation's rights to use the environment must not, and to use the environment and its resources must be in such a way that they should realize that there's an obligation for them to take into account how the longer impacts of some of their activities, and that's impact, if this must all be captured into the global regulation or national regulations that mean, so whether economic, environmental, or all sort of gains that we seek to take from the environment, we must have that as much as we are entitled to that, we must reduce the overexertion of our rights over the environment in such that the future generation can also benefit. That must be, so it's always connected to the concept of sustainable development. You must build, which looks at a long-term effect of activities, any form of activity that would eventually destroy the environment in such a way that the future generation, when they come around, would practically have less safe environments, must also be highly regulated. So that's the principle of intergenerational equity. So which must also be factored in when drafting regulations. So especially if you look at provisions of the Convention on World Cultural and Heritage and all that, those are some of the conventions that the international community has deployed some of these principles. So I think is that not, or which other one is remaining? So if you look at even in that, for that you can check the Stockholm Convention, and the Stockholm Declaration, and then this, of course, Sustainable Development Theory. Sustainable development is that principle that needs that the aspiration of common generation, like I said, connected to principle of intergenerational equity. So I think you can read up on sustainable development on that and some of the policies and the instruments that sustainable development has reflected. Any question? I think okay. So I think there's one that I think I put it in the handout to check, which is a principle of common heritage, a principle of common heritage, and that's self-explanatory in the sense that this environment is a common heritage for all of us, and we must protect it. So it's more or less intergenerational equity, sustainable development soon. So those are the basis. So I gave a couple of materials in case you want to read more on some of them. If you check the end of the handout, I gave some materials on sustainable development, materials on international principles of environment generally. So any question, please?
Yes.
Any question?
Sir, hold on, sir. Thank you, sir. What's the major difference between the what's it called? Sorry, the sustainable development theory and the principle of intergenerational equity? Because they look very similar.
They look similar. It's just international community playing with words up and down. They have the same goal. There's no difference. What matters is whether you apply intergenerational equity or you apply sustainable development. Most of the provisions on sustainable development are also the same things that reflect intergenerational equity. As long as sustainable development is a future looking approach to the environment, intergenerational equity is also applying that same thing, which is to think about the future, the long-term effects of environmental degradation. So essentially, to me, no difference to me, except that they are both two principles that seek to protect the environment in the long term. Does that answer your question?
Yes, sir.
All right, any other question? Any other question? Any question? Okay. if you don't have any more questions, I think we can go on and start preparing for TGIF. Tomorrow is Friday. Do we have anything to talk about again after tomorrow? I think this is like the second topic I'm supposed to take you. So I might I'll check if there's no other question, do tomorrow then. I think that we ought to do. All right. So thank you guys for coming. If you have any question, you can send to the class rep or send to me. I'm not sure if you have my number, but don't ask me funny questions, or I will not answer you. If you have serious question, send it to the class rep, and I will respond by answering that question, and then send to the class rep for the class rep to post. Since it is now a like an online drama that we are doing, so whatever question you have subsequently, and you are not in school, that you can walk into my office physically, send it to your class rep, and then I will do my best to answer and send to her to distribute with the class. All right. In the absence of any questions, so see you guys tomorrow. Bye.
Yeah.
Nice.
Hello.